Greetings, brothers and sisters. Welcome to another awareness session of Reconstructed Minds Incorporated in partnership with Positive Lifestyle Management and Ghetto Gospel Awakening and Sleeping Giant. My name is Shantario, aka Brother Midnight. Tonight will be the final awareness session to the series that I have been endeavoring to educate my brothers and sisters on the importance of the Jim Crow laws and how they affect voting and voter rights and what we are facing today in 2022 with the 19 states who are trying to suppress our voting rights, and also how this dynamic could ultimately affect getting the right people in position in the White House, whether in the House of Representatives or the Senate or even the president and ultimately the Congress. So without any further ado, we're going to get straight into it. As before, we have been discussing the Jim Crow laws, the minstrel that the Jim Crow laws was where the actual name of Jim Crow laws came from. The brother, the dude, Thomas Dartmouth Rice, how his minstrel show with the blackface, white people pretending to be black, the Separate Care Act of 1890, and how that ultimately affected all the states of the South during that time, and which ultimately led to a situation with a brother by the name of Homer Plessy, who was charged with violating the law, and was overruled by a Supreme Court judge by the name of Judge Ferguson, who was seated at the highest seat of courts. So without any further ado, we're going to get straight into it. Now, I'm going to be continuing to read from my notes in reference to the Jim Crow laws. It says, by 1915, the strength of the Jim Crow laws was slowly eroding. In 1915, the Supreme Court in Gwynn versus the United States ruled that the Oklahoma law that denied the right to votes to some citizens was unconstitutional. In 1970, in Buchanan versus Warley, the court upheld that a Louisville, Kentucky law could not require residential segregation, which ultimately set apart the whites from the blacks. In 1950, the Supreme Court ruled that the University of Texas must admit black man Herman Sweat to the law school on the grounds that the state did not provide equal education for him. So we see how intense this is and how it affects us ultimately as an organization. Education is an essential principle. Without education, we can't get anywhere. We need education, and without it, in the common sense approach, it says that we fail by, or we lose from what we don't know. So we see how this dynamic even affected another human being, another black man by the name of Herman Sweat. It says, but it was the Supreme Court's 1954 decision in Brown versus the Board of Education that overturned the court's decision in Plessy, holding that separate schools were unequal. And that's the issue we want to get to today. We want to dig into this Brown versus the Board of Education in 1954. Now, on May 17, 1954, in a landmark decision in the case of Brown versus Board of Education of Topeka, Kansas, the U.S. Supreme Court declared state laws establishing separate public schools for students of different races to be unconstitutional. This decision dismantled the legal framework for racial segregation in public schools and the Jim Crow laws, which limited the rights of African Americans, particularly in the South. So we see how difficult it was to be an African American in the South in the 1900s, and better yet, the 1800s, the 1700s, and even before that time. Racial segregation has always been an issue for the Black race because of a race or particular organizations thinking that they were superior or that we were inferior to them, that we didn't deserve a right to have the same equal education as them. Segregation in schools. Elementary schools in Kansas have been segregated since 1879 by a state law allowing cities with populations of 15,000 or more to establish separate schools for Black children and white children. African American parents in Kansas began filing court challenges as early as 1881. By 1950, 11 court challenges to segregated schools had reached the Kansas State Supreme Court. None of the cases successfully overturned the state law. Just one second, brothers and sisters, I have to step away to the restroom. I'm back. Now, continuing in this particular awareness session. Now, we see in the 1800s how this segregation in schools was targeting the separation between Black and white children. It said 15,000 or more established separate schools for Black and white children. Now, this situation in Kansas ultimately overturned the Jim Crow laws, and especially the case with Plessy versus Ferguson. The NAACP challenges segregation in court. In 1950, the Topeka chapter of the National Association for the Advancement of Colored People, in better words, the NAACP, organized another case. This time, a class action suit comprised of 13 families. The basis for the plaintiff's complaint was that their children were forced to walk or ride buses to reach segregated schools more than a mile away when there were white schools close to the houses. So this is crazy. You know, you had closer schools back then for the kids to go to, but because of this law, especially the Jim Crow laws, you know, we see how that affected the education of Black people back then. But the fight continues on to this day. We're still fighting for equal rights. You have people who are upstanding members of society in our Black community fighting for its right to this day. But the fight must continue, you know. And when I say fight, we don't have to necessarily fight with our hands and with our fists. Even though this approach was ultimately utilized by one of the civil rights activists by the name of Malcolm X, who believed in by any means necessary. He stood for the rights of the people, while people like Dr. Martin Luther King, who came years after what went on in 1950 and in the 1800s, who believed in a nonviolent approach, which ultimately led to him winning the Nobel Peace Prize in 1968. Dr. Martin Luther King adopted a philosophy from a man by the name of Mahatma Gandhi. Gandhi believed in a nonviolent approach for the rights of his people. Let's continue to read. It says the Topeka NAACP filed suit on the behalf in February of 1951, but by August, the U.S. District Court ruled that although segregation might be detrimental, it was not illegal, citing the U.S. Supreme Court's decision in Plessy versus Ferguson, which was in 1896. The judges denied relief on the grounds that black and white schools in Topeka was equal with respect to buildings, transportation, circular, and educational qualifications of teachers. But watch how the plaintiffs, the people, the NAACP appealed to the U.S. Supreme Court in 1952. It says they were joined by 4 familiar sponsored cases from Delaware, South Carolina, Virginia, and Washington, D.C. The court ruling combined the 5 cases under the heading of Oliver L. Brown versus the Board of Education of Topeka, Kansas. Mr. Brown was the assigned lead plaintiff in the Kansas class action suit and became namesake of the court decision. Chief counsel for the NAACP was Thurgood Marshall, argued before court that separate school systems for blacks and whites were inherently unequal, thus violated the Equal Protection Clause of the 14th Amendment to the Constitution. Now, Thurgood Marshall wasn't the only one. Even though this stated that he was the chief counsel, he wasn't the lead lawyer in this particular case. Now, a man by the name of Charles Houston was the lead man in this case. He led the way for what ultimately benefited Plessy versus Ferguson's decision. But Thurgood Marshall was the key strategist in utilizing this case that ultimately overturned Plessy versus Ferguson. It says Marshall argued that segregated school system had a tendency to make black children feel inferior to white children, and thus such a system should be legally permissible. Separate but equal has no place. This separate but equal thing was the Separate Care Act of 1890. But notice how the Supreme Court handled the case. It says the Supreme Court justices heard the case in the spring, but were unable to decide the issue by the end of the court's term in June. The justices decided to rehear the case in the fall with special attention paid to whether the 14th Amendment Equal Protection Clause prohibited the operation of separate public schools based on race. But if you go back and read the 14th Amendment, it says, and simply states, that that particular amendment was for the protection of all Americans. It didn't matter their race, whether they were white or black, whether they were from another, naturalized or born here. The 14th Amendment protected Americans in general. Check this out. It says, in September, Chief Justice Fred Vinson, who had been a key stumbling block to a unanimous decision, died and was replaced by Governor Earl Warren of California. Warren has supported the integration of Mexican American students in California systems in 1947. After Mendez versus Westminster, and when Brown versus the Board of Education was reheard, Warren was able to bring the justices to a unanimous decision. On May 14, 1954, Chief Justice Warren delivered the opinion of the court stating, "We conclude that in the field of public education, the doctrine separate but equal has no place. Separate educational facilities are inherently equal. Therefore, we hold that the plaintiffs and others similarly situated from whom the actions had been brought are, by reason of the segregation complained of, deprived of the equal protection of the laws guaranteed by the 14th Amendment. The decision in Brown versus the Board of Education forced the desegregation of public schools in 21 states and intensified resistance in the South." So it was basically the South. Because when a slave migrated to the North, they were considered free. So it was only the South that really pushed this initiative to keep the schools separated. They believed in the separated but equal doctrine, but the doctrine within itself went against the law. And we know, brothers and sisters, by being a part of an organization, the law governs all events. Now, as I continue to read, it says, "Therefore, we hold that the plaintiffs and others similarly situated from whom the actions have been brought are, by reason of the segregation complained of, or deprived of the protection of the laws guaranteed by the 14th Amendment." It says the decision in Brown versus the Board of Education forced the desegregation of public schools in 21 states and intensified resistance in the South, particularly among white supremacist groups. And we know who those groups are. You know, there's nothing private about these groups. These groups were the same ones that were hanging black men by ropes. These same groups that ultimately led the January 6th riot to reverse the votes in the presidential election. You know, it is no secret. You know, and the thing is, you know, we have to understand, we have to beat them with our intelligence. It might take some physicality as well, but we have to beat people with our intelligence. Why? Because the blueprint states the mind is the builder. So we have to move accordingly. You know, we have to stand for what is right. Check this out. It says, particularly among white supremacist groups and government officials sympathetic to the segregationist cause. In Virginia, U.S. Senator Harry F. Byrd Sr. started the massive resistance movement, who sought to pass new state laws and policies as a means of keeping public schools from being desegregated. In one of the most notorious instances of resistance to the decision, Arkansas's Governor Orville Faubus called out the National Guard in 1957 to keep black students from entering Little Rock Central High School. For African Americans, the Supreme Court decision encouraged and empowered many who felt for the first time in more than a half a century. Check this out now, for more than half a century. A century is 100 years, so for more than 50 years, They had a friend in the court. The strategy of education. Education is key, brothers and sisters. We cannot make it in this life without education. Now, when it comes to the organization, I want to read you something from the December 8th, 1982 letter. From the fourth paragraph, it says, as we have elaborated upon several times, in order for us as an organization to continue to progress and expand, we must become more educated, politically motivated, and aware of the economical realities of Black America. Only saying that we are an organization face the reality that this is not a one-man band who plays and moves all alone. Everybody must play the tune that he has perfected for our rhythm to be heard and bought. That is the reality of this thing of ours. We must come together. Now, I'm going to read you something from the common sense approach. It says, education is a major goal of this organization because its concept is the more knowledge you receive, the better your chances are for you to live the life that you want to. The thing is that learning how an education plays a major part in that. Education can mean having the job that you enjoy doing rather than having a job you must take to survive. It means supporting yourself, your dependent responsibility at the expense of your intelligence and not at the expense of a gun. Education means survival because history has proven that people pay for what they don't know. For over 400 years now, Black people have paid for what they don't know. Brown versus the Board of Education opened the door for Black people to have equal rights to education. This is key, brothers and sisters. We must master the 4 initiatives of growth and development, which is educational, economical, political, and social development. For African Americans, the Supreme Court decision encouraged and empowered many who felt for the first time in more than a half a century that they had a friend at the court. The strategy of education, lobbying, and litigation that had defined the civil rights movement up to the point brought into include an emphasis on a direct action. This included boycotts, sit-ins, freedom rides, marches, and other tactics that relied on mass mobilization, nonviolent resistance, and civil disobedience, all of which would come to define the modern civil rights movement. We must continue to educate ourselves, especially when it comes to voting. It's time to wake up, brothers and sisters. Wake up that sleeping giant within us. And come to grip with the educational, economical, political, and social realities of Black America. And with that being said, my name is Shantario, aka Brother Midnight. This has been another awareness session of Reconstructed Minds Incorporated. Love to you all.